Hi, I'm Andrew Bradley. I'm Head of Corporate at Bradley Haynes Law, and this video is what I consider to be the 10 steps in the process of selling a business or limited company. So the first stage will be to market the business, and this would generally be by appointing a broker or having negotiations with people that you know yourself. This process is generally done on an anonymous basis. The second stage I consider is then to appoint your professional advisors, because the earlier they're involved in the process, the more benefit they can be. So get your team around you, your broker, your solicitor and your accountant, and they can all work together in obtaining the best possible result for you. The third stage, once you've had some interest in the business, is likely to be a non-disclosure agreement entered into between you and prospective buyers, because they will need more information about the business, but you will want some protection about that information you're disclosing, particularly if it's to competitors. The fourth stage generally will be a preliminary financial review, so the numbers will be looked at. And if the numbers make sense to the buyer, then you may receive an offer. So the fifth stage will be negotiation of an offer letter or heads of terms. These documents are really important for both parties, because although they don't tend to be legally binding, in all areas there are some areas which are legally binding. For the buyer, they will want to secure an exclusivity period so they can conduct investigations and spend money on that. For the seller, obviously a key consideration is making sure that that process does not take too long. Once heads of terms have been agreed, the next step will be to proceed to what's called due diligence, which will be the buyer sending an information request about all elements of the seller's business. The buyer will probably base their decision to proceed with the acquisition based on the information that is received from that due diligence process. And from the seller, this process is important because it's the first chance to introduce any issues that might be within the business to the buyer. So once the due diligence process has concluded, and if the buyer still wants to proceed, they will issue either a share purchase agreement or an asset purchase agreement. Those agreements will, of course, contain all the commercial considerations, such as how much is being paid, when is it being paid, and on what terms. But the agreement will also have a number of pages relating to what's called warranties, indemnities, and covenants in relation to issues such as tax. And it's absolutely vital for the seller in particular that they understand those documents and their potential liability under those clauses. Also, whilst negotiating the acquisition agreement, the seller will be preparing what's called a disclosure letter. This is a vital document for the seller, as it enables the seller to disclose any issues about the business. The buyer would not be able to bring a claim against the seller after completion if those issues have been properly disclosed to the buyer. Once those two main documents have been agreed, there'll be the process of preparing all the other documents to transfer shares, to remove directors, and also documents such as consultancy agreements if there's going to be a handover period from the seller. Once all that is agreed, monies are paid over, and hopefully the buyer takes on a successful project and the seller is happy with the monies they've received and can move forward as they wish. I hope you found this note useful. If you're in the business of acquiring other businesses or considering a sale, we'd love to help you. Please feel free to give us a call on the following number and we'd be happy to have a free consultation.